So the one issue I wanted to talk to you about, I think that's quite interesting, obviously, is how to avoid getting dragged to U.S. courts. So first of all, let me just say this is not legal advice. You're not my clients. Don't rely on any of this. We're just kind of talking what's happening in the space. And if you have questions, then you can, call us later. But, don't take this advice. So as a bit of background, as you're probably all so well aware, 2017, huge, the ICO boom year. And now with the dropping prices, we're seeing a lot of litigation. Now, maybe that hasn't been yet as much of it in Europe, but in the US, there's a ton. There's almost about, I think, 100 cases now, various regulatory, civil, class actions, and even some criminal cases. And particularly, as you're probably well aware, the regulatory agencies are really aggressive in the US compared to their the agencies in Europe and other places. Particularly, I think it's funny, right? You've probably seen this one quote, but SEC considers, token securities, CFTC considers it commodities, FTC considers them consumer goods, IRS considers it property. Well, that's actually true. I mean, that's kind of what's happening. So, so the issue I want to talk about really is that the underlying jurisdictional question, really, they have to go through the U.S. courts. And now I'm just going to talk about one aspect of an important aspect, which is every U.S. court, and very similar here, they need to have jurisdiction over the cases brought before them. One part of it is in the U.S. what they call personal jurisdiction. That essentially is the question, when is it reasonable to bring a foreign defendant to U.S., essentially drag them there, make them pay the flights and litigate in the U.S. So that's a question the court has to answer before they can hear a case. That's pretty much for every case. So I'll sort of, and a lot of, and I think you most have seen this with ICOs, a lot of ICOs are trying to avoid that. They put in their languages saying, we don't want any Americans, no U.S. persons, none of the U.S. laws apply, and so forth. But still, we're seeing a lot of them have been dragged to U.S. courts. Courts have found jurisdiction. And after, I'll talk to Isha, there's some things companies can do that can help to prevent that, but we're still seeing a lot of people dragged there. So before talking about one particular aspect why blockchain might be different, which is, I think, is the location of the nodes and the reliance of various nodes processing information, I just want to give you general background and kind of useful steps that any sort of company, foreign company, should take to avoid being dragged into U.S. courts, that the courts would find personal jurisdiction. So I think, and if you haven't already, or your companies, one useful comparison to think of is to think about web-based providers, right? So you have online stores and so forth. Because the way U.S. looks at this is based on, decades and decades, or over 100 years of case law to determine when there's personal jurisdiction applies. They apply precedent. So this is, compared to the civil law countries, the common law country, like here. So they are applying old concepts also to blockchain technology. They're not coming up with new rules. So the basic rules still apply to everyone. And I think look to the online companies. It's, don't put your servers to the U.S. Don't target U.S. companies. When you're selling something, don't put, for example, $ next to the items. Because all of those things indicate that you're trying to reach into the U.S. and do business with U.S. people. So, and if you already have lawyers, you should kind of look to that as the first steps to take, see how those companies have structured and avoided personal jurisdiction in the U.S. Now, specifically, why I think, blockchain is so interesting, and from the jurisdictional aspect, is nodes. So, essentially, let's take some of the big ones, Ethereum and Bitcoin. We have nodes basically all over the world. And I think the two key issues, and I think these have been pointed out before, are, two things. Where's the cluster of the nodes? Where's the majority of the work has been done? Also, but maybe where has that transaction been mined? Where is that one single been entered onto the ledger? So, and people have asked, especially, so far the litigation has been ICO related. So we're not really seeing litigation stemming from the use of the blockchain itself, right? It's not about on-chain transactions, something that went wrong. Maybe something was hacked or was a technological problem. What we're seeing is just very simple, usually mostly securities law cases that have made their way through the courts. Only, for the last couple of years, we don't have any clear answers. We're getting new answers all the time. So we really haven't been seeing the issues discussed so much about what happens on the chain itself. It's more about raising money. But nevertheless, the question is out there. So is it enough, for example, that you rely on nodes that are mostly in America that process the transaction, even if you're abroad, you're not selling anything to Americans? Maybe even the other side is abroad. Could that for example, is a single node sufficient to create personal jurisdiction? If a single node is in the U.S. I mean, people have asked the question. There's no answer to it yet. Hopefully that's not the answer. Or in my mind, maybe that's a little too aggressive, just that one node, process something in the U.S. So now, fortunately, just in the last couple of months, we have first cases that are grappling with this specific issue, location of the nodes. So, and actually, let me provide you a little bit of background first, how this fits into the issue of personal jurisdiction. So, there's two parts of personal jurisdiction. There's something called general personal jurisdiction, and there's something called specific personal jurisdiction. General personal jurisdiction isn't really worth talking about today because that applies if, for example, U.S. is your home jurisdiction or that's your principal place of business. I mean, if that's what you want to do, you're going to be subject to jurisdiction, so we're going to leave that aside. The second part, though, is specific personal jurisdiction. So what that looks and, of course, it depends also on the claims being brought against you heavily, but let's, generally what it looks at, and this is based on the U.S. Constitution, and there are, specifics for state law. We'll kind of leave that aside as well, but everybody has to look at first due process kind of requirements under the Constitution, and there's a three-part test for it. Essentially, it's a question about, do you have minimum contacts with the U.S. or the particular state where you're sued? And have you taken some steps? Have you purposefully availed yourself? Or have you shown some intent to do dealings or to participate with that state or the U.S.? That's kind of what the court is looking at. So and then, if you have, they say, therefore it's fair to bring you to court to go through all of this litigation. Particularly, the test is three-part. One is relatedness. Are your contacts related to the claim that's brought against you? And we'll leave that aside for now because it depends on the claim. But the second part, I think, is most important, which is, and often the most fact-intensive analysis, which is called purposeful availment. Have you purposefully availed yourself to the U.S. or a particular state's laws so that it's fair to bring you to court? Last part is called reasonableness. That's a general where a court considers factors, for example. Is it very difficult for you to come? How important are the laws for the U.S. at stake? What are the other issues? So that's kind of overall comparison. So now what courts have found on this purposeful availment issue recently, one of the cases is in relation to the Tezos class action litigation. And you're all aware of the Tezos ICO, I assume, right? Pretty much everyone? Or Tezos? Yeah? Right. Raised $232 million, sixth largest ICO ever. So basically now what they also try to avoid U.S. jurisdiction. So what they did is they set up a Tezos Foundation in Switzerland. The Swiss Foundation then was going to sell the ICO tokens to people elsewhere, and they put in the contract saying, Alderney Law, which apparently I Googled is a small British island, Channel Island, that, therefore there's no U.S. connection. So basically what the court, although not analyzing personal jurisdiction, it tried to answer the question, where did that transaction or sale of the cryptocurrency occur? And one of the factors they actually listed that they analyzed was, hey, where was this? So because they bought it with Ether, where was Ether entered into the chain? And they said the majority of the nodes, the cluster nodes in the U.S., and this is a relevant factor for establishing jurisdiction. So this is a recent case now, district court decision. Although it was analyzing about extraterritoriality of the U.S. securities laws, the same principle applies. I think, they might be looking at the same thing for personal jurisdiction. Fortunately, another case just last week, which is Alibaba suing Alibaba Coin, looked at the same issue. Alibaba Coin, which is a Belarus and Dubai entity, said, hey, even though they sold to some people in the U.S., they said, hey, the transaction wasn't in the U.S. because the nodes, that mined the transaction were in Belarus. The court said, give me a break, basically. It's similar to any debit card transaction online. It doesn't matter where it's, where it's just processed. You have to look, where it's purchased and other factors. So there's no agreement on it, but I think looking forward, it's a very important consideration. So basically, think of every ERC20 token, right? If basically it's now considered the cluster of Ether is in the U.S. and you build on top of it, could it possibly mean down the line that there's personal jurisdiction, and you're subject to U.S. courts, at least from that point of view. So that's kind of what I wanted to give you the idea of something to be aware of and keep an eye on. Now, generally, there's steps you can take to avoid this. So obviously what to do, get good lawyers. Yes, go Warwick. But something to look at is the dispute resolution clause. It's very important. Again, and in the Tezos case, they try to take some steps. I think it's important, and the court, talked about it. The fact that they said, hey, an ICO token is purchased in Alderney, for example, right, British Channel Island. And they said, Swiss law and Swiss courts. Like, those are still good steps to take. But another important aspect is also, especially U.S. courts, and the court pointed out, is there's a difference between something called the browser wrap, which is, when you have to scroll down in a certain terms of agreement. That's not great. much better is to have a clicker app. It's when you actually have to click through, it appears, and you can make for sure this person had noticed. So this already is a good step to take that might limit jurisdictional questions. Now, and that's pretty much it. I'm just going to mention, obviously, that there's other questions that matter. For example, every claim and every law might raise questions of extraterritoriality. So there's been questions now, U.S. securities law, how broad they go. They seem to be going pretty broad now. But you might have a trademark issue, patent law, RICO claim. These are all fact-intensive based on law. There's decades of precedents. And, a good lawyer can make a difference. And there's ways to fight that when that issue comes up first. So, yes, that's pretty much what I had. Thank you very much for listening to my pitch. Thanks so much.
Thank you. Well done. Brilliant.